The concept of rule of law is not new to the human race. From the inception of the society, the spark of equality among the different classes begins, wherein the concept of rule of law taken birth. With the evolution of law, the concept have taken a form and established as a right. The concept supports the equality of all citizens before the law has been found from the various writings since the 4th century BC. Aristotle has differed the rule of law with that of an individual. To him, law should govern and those who are in power should be servant of laws. To Plato, where the law is subject to some other authority and has none of its own, the collapse of the state, in my view, is not far off. But if law is the master of the government and government is its slave, then the situation is full of promise and men enjoy all the blessings that God shower on a state. The term rule of law is taken from the French phrase La Principe de Legalite. The rule of law touched the British soil at the time of signing of the Magna Carta during the rule of King John in 1215, and today it became the important feature of the British judicial system and act as the guardian of the rights and liberties of the British citizen. Sir Edward Coke forwarded the concept as king is under the God and law. In 1885, A.V. Dicey developed the concept in his book The Law of the Constitution and converted into the doctrine of rule of law. Dicey, the chief exponent of the rule of law, had forwarded three major ingredients. 1. Supremacy of law. No man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established in the ordinary legal manner before the ordinary court of the land. 2. Equality before law. Every official from the Prime Minister down to the constable or tax collector is under the same responsibility for every act done without legal justification as any other citizen. 3. Predominance of the legal spirit. Result of judicial decision determines the right and liberties of the private individual brought before the court. It has become the part and parcel of the British Constitution. This doctrine has also touched the US judicial system. In the word of Caroline Kennedy, the bedrock of our democracy is the rule of law, and that means we have to have an independent judiciary, judges who can make decisions independent of the political winds that are blowing. The term rule of law has not been defined in the Indian Constitution, but the judiciary has discussed the term in its various pronouncements. Some of the notable cases where the rule of law has been discussed are 1. Keshavananda Bharati versus the state of Kerala in 1973. 2. Indira Nehru Gandhi versus Raj Narayan in 1975. 3. Union of India versus Raghuvar Singh in 1989. The importance of rule of law is immense in the legal system. The matter of equality before law from the Prime Minister down to the constable, as it protects the right and liberties of the individuals. Let us now envelop in the word of Wade and Phillips. The exercise of the power of the government shall be conditioned by the law, and that the subject shall not be exposed to the arbitrary will of his own ruler.